All right, hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I am your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court. And I hope you're just having the most fantastic day. We are here today to discuss the Take Care of Maya trial, as it finally reaches something resembling a conclusion, which we are all very excited about, I'm sure. As this trial has been going on for what seems like forever, 9 weeks. And the jury is, I'm sure, getting a little bit perhaps tired of the whole thing. And their question today seemed like maybe the jury's punch drunk, because otherwise nothing makes sense. Maybe the jury's losing the plot too, which at this point isn't surprising in some ways. So we are still on verdict watch, and we're going to discuss where we are. So I thought first we would just start with the fun and frivolity element of the thing. We would start with the juror's question as the judge is reading it to them, because I don't know, does the jury not realize it's serious or something? Because it was a very strangely worded jury question. I'm not sure I've heard a jury question phrased quite exactly that way before. Don't know what that was all about. Seemed odd. Don't really understand it very much. So I thought we could start by watching this jury question at the end of today's hearing and go from there. So we'll just do that real fast. So let's go ahead and do this. And that's my mug. You don't need to see me twice. As much fun as I am. There we go. All right. So let's listen to this jury question tonight. So this is the very end of the day. This just ended. This is like 10 minutes ago in real time. Let's listen to this. The jury get dismissed for the day, where they read this jury question. It's like, what is the question exactly? All right.
Okay, members of the jury, I've received two notes. One is at 6:15 will be done. Thank you. And then the other one says as follows: y'all, we have not been able to locate any of the calculations about future amounts. Witness Kirby was on Zoom and Whitney mentioned them today, and it was said that we'd have all this at deliberation. Well, if we do have it, we ain't found it in all these files. So without these witness figures, you'll be lucky if there's enough awarded to pay your gas to drive to court, or we'll be here till next Friday. So
that apparently was the question. I'd like to take note that it really ended a question mark. But first question is, we'll be done at 6:15 or 6:30. Second question is long rambling diatribe. I just want to hear the question again, because it wasn't that coherent the first time. So we'll just listen to it a second time and see if we can all figure out exactly what the question is.
Okay, members of the jury, I've received two notes. One is at 6:15 will be done. Thank you. And then the other one says as follows: y'all, we have not been able to locate any of the calculations about future amounts. Witness Kirby was on Zoom and Whitney mentioned them today, and it was said that we'd have all this at deliberation. Well, if we do have it, we ain't found it in all these files. So without these witness figures, you'll be lucky if there's enough awarded to pay your gas to drive to court, or we'll be here till next Friday.
Is it just me, or does that seem a little inappropriately informal for this setting? It isn't the witness referred to future earnings calculations. We can't find them. Can you give us a copy? It's whatever that is, and something about gas. And if you don't give it to us, we won't award you gas money. Okay. And then the judge asks, is that correct? And the juror's response is also not exactly super encouraging.
So did I misread that? No. Kind of? Well, I mean, this is serious. I mean, if I didn't read it properly, let me know. Okay. Let me.
So, did I misread it? Kind of. And the judge is like, this is kind of serious. It's kind of important that I get it right. Is that what you wrote? And she's like, yes. So Um, that happened. So I don't know if the jury's trying to tell a joke, but it doesn't seem like the most appropriate venue for a joke. Uh, so I didn't think it was really great there. Okay. We'll listen to what the judge says about it.
Let me say a couple things. One, you have all the evidence in this case. And so you're going to have access to everything that's there. And since we're going to be closing down for the evening, I am going to ask the clerk's office to go in and grab the evidence so we can put that in a lock room tonight. Your room's going to also be secured, but the clerk has its procedures and we need to do that. So if the clerk can go ahead and do that right now. Now, with respect to the specific request, in discussions with the attorneys, there's a possibility that we can have what's called a read back of the testimony of this witness or some portion of the testimony. Getting a read back, though, does take time. It's not any sort of instantaneous thing. We're going to see overnight if we can get that transcribed in a hurry. Can't promise, and I don't want to promise. So that could be an option for the jury. And if ultimately that is something that the jury is going to want, we can, if we're able to get that, we can give, if you give us a specific, what you're specifically looking for, then we can try to read back that portion or portions that the jury designates. So perhaps that is the way to address this specific issue. That being said, I have now been handed a sealed envelope with.
All right, so we'll cut it off there because the rest is just housekeeping stuff. So we'll cut it off there. So the judge also points out during the time that they dismiss the jurors that they have no alternates left. And it seems odd that this is the way that Florida does this, where they dismiss, they don't not only dismiss the alternates, but they release them. Because I've never really seen that before. I've seen where they keep the alternates, in a side room somewhere. That happens a lot. And I've certainly seen where they let the alternates into the world, but they say you're still under the instruction until we call you and tell you otherwise. So if we need to pull you back, we can do that, right? You're still not to see any media. You're still not to talk about it with anybody. You're still not to do any investigation. You're still under all the same guidelines that you were before. It's just now you can go out into the world. If we need you back, we'll call you back. But in Florida, apparently, they don't do that. They released all the alternates. They were very clear during the instructions that they were released. They're like, yeah, you can do whatever you want now. You can talk to whatever you want. So they have no alternates. This seems like a very odd way of going about it. So in the unlikely event that one of the alternates, suddenly, falls ill or, passes away or something, which, is not exactly impossible. Maybe someone gets into a car wreck or something. They have no alternates, and we have to start this whole thing over. How much fun is that? How much fun is that? So I don't understand that this is the way that Florida does it, but apparently this is the way Florida does it. So, yeah, I don't think it was a mistake by the judge. You don't make that kind of mistake. If that were a mistake, counsel would be, standing up objecting and be like, no, that's not what we do, Your Honor. That's not the right procedure at this time, Your Honor. That seemed like everyone was on board. That's not a mistake. So that's, the attorneys say that if they agree they can deliberate with 5. If I'm Johns Hopkins, I'm not sure I agree to that, to be honest. So the rules allow for them to deliberate with 5 if both sides say yes. I'm not sure I say yes if I'm Johns Hopkins. Why would I say yes? So, yeah, I wouldn't be really super optimistic about that. Yeah. Peter Trego says sometimes they'll agree ahead. Why would they, though? Why would they agree? Johns Hopkins, I don't believe that. I don't believe that they would agree. I believe it's a rule. The federal rules of criminal procedure also incidentally allow for a jury of 11, in case you care. but I don't think they would allow for it in this situation. So what is theoretically possible and what is true in this case, I don't think are the same thing. So what we're going to do for tonight is I'm going to summarize Maya's closing, and then I'm going to summarize Johns Hopkins closing, and then we're going to listen to the rebuttal close from Maya. But I'll summarize the other portions. But before I do that, one of my mods on my channel was very kind in putting together a list of the issues they think the jury has to resolve. And we counted 49 issues the jury has to resolve. So here's the issues we think the jury has to resolve. We don't actually have a copy of the jury questionnaire. We don't have a copy of the verdict questionnaire. We don't have a copy of the instructions. So we're basing it off of readbacks because we don't actually have it. If I actually had the document, I just read you the document. But since I don't have it, we're basing it off of readbacks in our perceptions. So here's what we think the issues the jury have to resolve are. Okay. Was Johns Hopkins responsible for the claim of false imprisonment between October the 7th and 13th of 2016? This would be because they didn't allow her to leave, right? This would be because they didn't allow her to leave. That's false imprisonment. It's kidnapping, but the civil version. You didn't allow her to leave. Okay. What are the damages for future medical care for Maya before 18 and then subsequently after 18? What are the damages for pains, suffering, loss of capacity for Maya after 18, as distinct from medical? Damages for Maya's hospitalization and care prior to 18, including for the false, fraudulent medical billing. General punitive damages, we haven't gone that far, but that's still to come potentially. Whether Johns Hopkins was responsible for the claim of false imprisonment from the period of October the 18th to the 20th of 2016. What are damages for future medical care as a result of that? What are damages for pain, suffering, loss of capacity for Maya after 18 as a result of that? What are damages for Maya's hospitalization and care prior to 18 as a result of that? So you got two separate false imprisonment claims, each of which you have to answer the questions as for both. So that brings you up to 10 when you get to general punitive damages. Was Johns Hopkins responsible for a claim of false imprisonment on January 6th? So now a third false imprisonment. What are the damages for future medical care after 18? What are the damages for pain, suffering, loss of capacity for Maya after 18? What are the damages for hospitalization care prior to 18? What are the punitive damages brings you to 15? Okay, so count one basically has 3 subcounts, which causes 15 questions. Then you have the claims of battery, which is for physical touching. That's what battery is. Unwelcomed physical touching. Okay. Against Beatty and any other nurse that might be involved. Did Beatty or any other nurse commit battery, which is to say an unauthorized touching, by having them, by hugging them, kissing them, or other conduct? What are the damages for psychiatric treatment after 18? What are the damages for pain, suffering, loss of capacity after 18? Damages for hospitalization care prior to 18, general damages. Specifically, did Betty's hug, pat, kiss, place Maya upon her lap create a battery? That's a separate question. What are the damages found for continued psychiatric treatment for Maya after 18? What are the damages for pain, suffering, loss of capacity for Maya after 18? What are the damages for Maya's hospitalization care prior to 18 for awarded to Jack? For 2 separate batteries, for 2 separate unauthorized touchings. Okay, then we get into claims of medical negligence by Dr. Smith. First of all, we have to get to the issue of whether Dr. Smith is an agent or a parent agent of the hospital. If she's not, then none of this matters, right? Because Johns Hopkins is only respondent if Smith is their agent or apparent agent, respondeat superior. The employer is responsible for the conduct of the employee. So if Dr. Sally Smith is not an employee or an apparent employee, which is to say an agent, if we're using it in more formal legal speak, an employee is an agent. If she's not an agent or an apparent agent, then that doesn't matter. And Johns Hopkins made some arguments, which we'll get into, that she's not an apparent agent, which I think are actually fairly reasonable. But we'll get into that when we summarize their arguments. So, assuming that Dr. Smith is an agent or apparent agent, which is not inherently obvious, was Dr. Smith negligent or reckless in her care of Maya? In a medical sense, which is also disputable, was negligence a cause of damages? Was her negligence a cause of damages? Excluding conduct by Dr. Smith, did one or more other hospital staff cause damage to Maya? What damages are found from future loss of earnings income for Maya? What damages are found for past or future pain, suffering, loss of capacity for Maya as a result of all that? Then we get into claims of fraudulent billing. Their billings were false. They were fraud. They lied on their bills. There's fraud. Did Johns Hopkins engage in false billing? Now, by the way, to be fraud, of course, it doesn't have to just be wrong. It has to be a lie, right? It's not enough that you make a mistake. Fraud requires it be deliberate, right? So it has to be deliberately false, not just a mistake or confusion or uncertainty. It has to be they were doing it on purpose. They were trying to bill falsely, purposefully. So did they do that? Did Jack and his insurance agents rely upon these false billings? Because if they didn't, there's no harm. The fraud requires reliance. If there's no reliance, there's no fraud. At least there's no damages as a result, which is basically the same thing. Assuming they did rely, what damages are found with respect to deductibles, copays, or increased insurance rates for Jack or Maya is a separate question. What damages are found for difficulty in finding future insurance as it relates to Jack or Maya? So that brings us to 33 questions. Claims for emotional distress from Beata's estate. These are non-death related psychological damages to Maya's mother. It's intentional infliction of emotional distress, right? So you have to find that Johns Hopkins, through their actions, intentionally caused emotional harm or recklessly disregarded, which is to say that they engaged in wanton, careless, devil-may-care, laughing in the face of harm. There was awareness that there would be a problem and they just didn't care. They have to consciously and purposefully disregard to Maya's mother. And as they pointed out as Johns Hopkins pointed out in their closing, this is not relating to the Munchausen by proxy because they're not suing for that. It's other things that they did or didn't do. So what did they do to Maya's mother, and was it intentional or unconscious, reckless disregard? In a way that is problematic, which I think is questionable under the law. Did Johns Hopkins intentionally cause the action? What damages are found for the mental distress before Maya's mother's death? So what are the damages other than as a result of death? Then separately, the wrongful death claim, which is also just a adjunct to intentional infliction of emotional distress. So if you don't find intentional infliction of emotional distress in 5, you don't get to 6. You have to find the intentional infliction of emotional distress in order to have a viable claim for wrongful death. So first you have to find that Johns Hopkins engaged in acts of extreme disregard or recklessness or intentionality that led to Maya's mother's self-deletion in a legal sense, which is not at all legally obvious. And regardless, if the jury finds yes on this, we're going to be appealing it forever, at least for the next several years, probably longer. Did Johns Hopkins' actions create in Maya's mother an uncontrollable impulse for self-deletion? I think the answer is no to this on the facts. An uncontrollable impulse, an irresistible impulse is something that occurs suddenly. And this isn't Maya's mother, pulling out a sidearm and doing, hurting herself that way. This is her, stringing up a rope in the garage, which requires a little bit more deliberation than irresistible impulse would imply, right? Irresistible impulse is essentially unconscious. It's essentially thoughtless. Because if you're thinking about it, right, then it's not irresistible. It's almost automatic in its nature. So I think irresistible impulse, I don't really think the facts support that, given the manner of death, but that's just me. Also, I'm just skeptical of this cause of action as a whole, as I've expressed before, so that could be part of my skepticism here. I'm skeptical for this for legal reasons. I'm not sure this is legally tenable. And I'm not sure that the facts support an irresistible impulse within the meaning of the law. But that's where I'm sitting on this thing, which I know is not what some of you guys want to hear, but I'm a legal analysis channel, and I'm trying to give you my best legal analysis, which isn't always what you want to hear. And I'm sorry for that, but it's kind of the situation. So assuming that you find that, assuming the alternative is that to the irresistible impulse, you could also find in the alternative, or in addition, that Johns Hopkins' actions were a substantial factor in the self-deletion, which I'm not even sure what that means. And I'm an attorney, which isn't super promising. So I don't know exactly what that means. And I have real problems with this because if it could be used, if it could be used as a substantial factor in Maya's mother's deliberate action, because at this point it's not an irresistible impulse, so it's a deliberate action. Like, that's implied, right? If it can be used for that, then it seems like it could be used for anything, right? If the hospital's actions didn't induce a sense of hopelessness and depression in Maya's mother that caused the suicide, but instead caused, let's say, a sense of anger and outrage that caused Maya's mother to react violently towards someone else, right? She became physically violent towards someone else. Could you use the same underlying cause of action? Because either way, arguably, the hospital's actions are a substantial factor in Maya's mother's actions at that point, even though she's making an independent decision within the meaning of the law. And that raises some really uncomfortable possibilities. Salazar in chat says, do you think this case could end up going to the Supreme Court? I 100% guarantee this is going to the Florida Supreme Court. There is no way this is not going to the Florida Supreme Court if they rule for Maya. There is no way this doesn't wind up in the Florida Supreme Court someday. If your question is, does this wind up in the U.S. Supreme Court? I don't see how, because I'm not sure there's any federal cause of action here. So I don't see how it ends up in the U.S. Supreme Court, because there's nothing for the U.S. Supreme Court to do, because there's no federal issue here. And the U.S. Supreme Court only decides federal issues. It's the U.S. Supreme Court. But will this wind up in the Florida Supreme Court? 100%. I can pretty much guarantee it. All right. So are they a factor in the self-harm? What damages are found for the loss of net accumulations in income, so income loss? What damages are found for loss of the wife's support and funeral expenses? What damages are found for loss of companionship, loss of consortium, as we like to say when we're all fancy, right? Loss of consortium. What is the loss of companionship for Jack? What are the damages found for the loss of the mother's support for Maya? What are the loss of consortium for Maya? What damages are found for the loss of Kyle? What damages are found for loss of consortium for Kyle? There's 3 separate causes of action that have to be measured. And that finally brings us to Claim 7, the claim for intentional infliction of emotional distress to Maya, separate from her mother. And did they intentionally cause emotional distress what damages are found for those earnings, and what damages are found for pain and suffering. So that takes us to 48 questions that we counted. Yeah. Sarazar says the jury's not going to listen to Kurt. As I pointed out, these are questions of law. If you're asking me what the jury is going to do, I think the odds are very high. The jury is going to award big dollar damages for Maya. But that's in no sense the end of this rainbow. We all know it's not the end of this rainbow. Why will it go to the Florida Supreme Court? Because it's a novel question of Florida state law. It's a novel question of Florida state law, and that's where you go to. There's no way that stops at the Intermediate Court of Appeals. It's a truly novel question of law. There has never been a case, ever, before, where someone's self-deletion has been a viable damage in an intentional infliction of emotional distress. It's never happened before, ever. Or at least it's never gone to a jury before, ever. It's a first. It's a first, right? It has never happened before. We have never had, ever, an intentional infliction of emotional distress claim with self-deletion as the predicate basis damages for the intentional infliction. The reason is because self-deletion is seen as an intentional act that breaks the chain of causation. And so, because it breaks the chain of causation, it's not a viable cause of action. This judge is literally trying to invent new law before your eyes. He's trying to invent a completely new cause of action. And so, it's going to get appealed. It's going to get appealed to the Intermediate Court of Appeals. And this isn't just some sort of, tweak on the law. This is a novel application of law, and I don't think that there's any chance this doesn't wind up at the Florida Supreme Court, because it is a novel in the most strict sense. It is a novel application of law, and I just feel like there's no way this doesn't end up at the Florida Supreme Court someday. So my odds of it appearing before the Florida Supreme Court are roughly 100%, because Florida Supreme Court has to figure out whether or not this is a viable cause of action. So that's why I say that. You disagree with my read of The Irresistible Impulse? Okay, well, noted. That's my legal opinion for whatever value it has. So I'm not aware of any time it's ever gone to a juror before on this kind of thing. So, maybe I'm missing something. It's possible I'm not God, but it seems novel. I'm fairly reasonably educated. I've never heard of it before. So, I didn't, yeah. So, yeah. So I think it's novel, and I think it raises serious problems. So if you're asking me what the jury's going to do, I think the jury's going to award for Maya. I think they're going to award big dollar damages. And then there's going to be a motion for remitter. In other words, trial judge, please lower the amount. Because the trial judge basically warned plaintiff's counsel during closing argument. He basically all but told them, I'm going to reduce the amount. Because he told them during closing arguments, he said, look, I have to do what the law requires, even if I don't like it. So you got to make sure that what you're asking for is supported. Basically telling them, you're asking for too much. So the judge has basically all but said, if you get what you're asking for, I'm going to reduce it by law. They replaced irresistible with uncontrollable. I'm not sure what the difference is between irresistible and uncontrollable. I'm not sure there's a difference between those two things, but yeah. So that's sort of where we're sitting. So yeah. So I think the jury is going to award big dollar damages. There's going to be a motion for remitterer. The judge is going to probably reduce the damages, and everyone appeals. And we spend the next 4 years in appellate hell, bare minimum. They'll have to overturn the IJ. I don't think they'll overturn that aspect of it. That seemed perfectly proper. Yeah, so that's not the issue. So, yeah. All right, so let me give you a summary of the arguments from both sides, and then we'll listen to the rebuttal portion of the testimony of the argument, because I think it's important. Yeah, they're trying to use some of the comparable examples to changes occurring in criminal law. Yeah, they are, but the problem there is they are trying. It doesn't really work. The criminal law is set up by statute, and to a large degree, a lot of those cases dealing with criminal cases are because the legislature has, by legislative act, opened up the language, which is a totally different thing, right? So the legislature has, over the years, generally speaking, because I'm talking about, in all 50 states now, so I have to speak in a very sort of global way. But the various legislatures have passed laws that have changed the definition of harassment, added new definitions of harassment, and particularly created a new cause of action in cyber harassment. So a lot of the criminal cases are coming about because the legislature passed a law. And the courts are like, well, we do what the legislature does, which is fine. This is different because in this situation, the Florida legislature didn't pass a law. The court is attempting to create a new cause of action or a variation on a cause of action as a matter of common law, which is to say the judge is just making it up, which is certainly part of common law. It's not exactly unheard of, but the examples to the criminal law that some of you guys are noting is somewhat in opposite, because in many of those situations, the legislature has deliberately opened up the language by legislative act, and here the court is just making something up. So it's a little different. So, yeah. So that's the difference. So anyways, let me summarize the case. Wasn't there a bullying case where unalive was included in wrongful death? Yes, there was a manslaughter charge out of somewhere in the Northeast, I want to say Connecticut, where it was manslaughter. But again, you're talking about, the situation is a little inopposite. And also, not for nothing, but it was incredibly controversial in that case for very similar reasons. I believe ultimately she pled out, though. They offered her enough time. Massachusetts, I knew I was somewhere in the rough area. Yeah, Massachusetts. I said Connecticut, Massachusetts. They're like the same state, right? So ultimately, that girl pled out, I believe, as memory serves. And so, as a result of that, we never got the issue tested. If she had stuck to her guns and refused to plead and took it all the way to appeal, who knows what would have happened. But because she, was offered a generous enough plea, she took the plea, and we don't know. But in a lot of ways, that case was also controversial for the exact same reason, because we, including yours truly, thought that they were pushing the law to do something it wasn't meant to do, and there was a very similar problem. JT says, I'm just a 3L, but agree with you. Applaud you for taking a tough crowd on IAD. P.S. I've always worked for plans firms. I wish it was different. I'm new and I'm glad I found your analysis. Thank you. I always just try to provide good analysis. I always just aim to provide good analysis, which often means I can't tell you what you guys want to hear. But yeah, it's like, and so that Massachusetts case was very controversial for the same reason. In some of the other cases, it's been because the legislature has passed specific acts or amended acts or passed cyber law or other things. But here, the judge is just trying to make something up. So she did go to trial and it got appealed and it was upheld, then I stand corrected. And I don't know that decision off the top of my head. So I don't know what the decision there or the rationale was on that, but there were a lot of questions for the same reasons. So, and you don't know what the court is going to do. So if she took it all the way and she appealed it and the court upheld it, then, then that's a decision. But that's still a matter of state law, right? So everything I'm telling you is still true. Is right. All I really said to start with is like, yeah, this is going to the Florida Supreme Court someday because it's a new cause of action. And so if you're right that she didn't plead out and she appealed it, then it went to the court and they upheld it. So, but I don't know that the law's prepared to do this here. I don't know that they're prepared to do that here. And, that's just one man's opinion. I could be wrong. We'll see. Do you know if the judge passed on the sanctions? I believe technically they're still pending, but he's not going to do anything about it. So, yeah. She served only 11 months of a 15-month sentence, yeah. So, yeah. So if they appealed it, then then the courts upheld it. So, maybe it will be the case that the Florida Supreme Court will someday say this is a valid cause of action. I'm dubious, but I'm not the Florida Supreme Court. All I'm really trying to tell you is that it's a novel cause of action, and it's going to go to the Supreme Court, and God only knows what happens next. Anyways, trying to get back to the summary of the closing arguments, because you guys keep asking good questions, and I'll get there eventually. Trying to get back to the summary of the closing arguments. All right, so Maya's attorney on their opening, on their start of their close, on the first part of their close, was a little disconnected. The rhetoric was good. They had good illustrations, and I liked their verbiage. They had a very, very illustrative style in their language, which I appreciate. They were very good with painting a picture, using words. So they were very good. My criticism of the plaintiff's side, I had two criticisms. First, it was a little bit more like an opening than a close. What I mean by that is it didn't very well integrate specific facts and specific testimony into the close. There were a few examples of that, but for the most part, it was very narrative heavy. It didn't really adequately or substantially bring in portions of testimony, a quote from this witness here, a quote from this witness here, a little piece of testimony here goes a long way, right? It was a little bit too narrative heavy. Second criticism I had of it was that the overall narrative and story was a little unclear. It was every part of it was good and effective, and it was like good lines from a good story, but it lacked a cohesive flow. It lacked a story and narrative flow. And opening and closing, and the trial as a whole is about storytelling, right? You want there to be a story, and you want to have the story, end in a way that there's only one possible result, which is the jury decides for you, right? You want there to only be one satisfactory ending to the story. And so the ideal is you want to put together your case in a narrative arc, like you're writing a story, and tell a story, because people like stories and they help to connect the whole thing. So they didn't really do that very well. I was listening to their I was listening to their closing, and I was very challenged by it, because every time they said something, I didn't know what they were going to say next, which was very unsatisfying. I didn't know what's going to happen next because I didn't know what the story is. Any good story, there's only there's an implicit representation that the story is going to unfold in a logical way. And so the story can only go so many different directions, and you kind of know what's next in the story. Even if you've never read a book before, even if you've never seen the movie before, you kind of know a little bit what's next in the story. Because there is a narrative flow to it, and there's a place that it's going, and you've seen enough stories, and you've read enough stories, and you've seen enough movies that you know sort of where it's going. Right? Even if you've never seen this particular movie before, even if you've never read this particular story before, you've read enough stories and you've seen enough movies, you know how stories work. So even subconsciously, you kind of know what's next in the story. You know where it's supposed to go next. And if it doesn't do that, for whatever reason, it's very unsatisfying. So it can be unsatisfying because either A, they broke the promise, they broke the implicit promise of the story because, then magic occurs in a non-magical story, right? Deus ex machina, something just completely unexpected happens, which isn't satisfying. Or it can be unsatisfying because there's no real story to keep everything grounded and cohesive. So I liked what they were saying in their segments. I thought it was good. The rhetoric, it was a little rhetoric heavy. It was a little narrative heavy without actually having a cohesive narrative. And so I was like, and also they didn't really integrate the specific pieces of testimony very well, which was a little unsatisfying. Then during the first part of the opening, they also had another lawyer get up and talk about damages to get them to this $232 million number. They were basing this a lot on $100 per hour damage calculation, times 8 hours a day times 60 years equals X dollars, which seemed inflated. And I think the judge's concern that they're inflated is very warranted. The damages that occurred are not really of the kinds of amounts that Maya's team is asking for, in my humble opinion. They are way shooting the moon, in my humble opinion. They did have this sort of clever line at the end there, like how much would plaintiffs pay for 1 hour more with their mother? Would they pay $100? Would they pay $1,000? Of course they would. Which, yeah, that's true. But to say that you're suffering $100 of value every hour because you're not with your mother is not quite. It's a cute line, but it doesn't quite work, in my opinion. So their ask is just way too high. Johns Hopkins, for its many sins, was giving a much more reasonable estimate of damages. First of all, they deny everything, but they were giving a much more reasonable calculation. So, yeah. Someone asked in chat, says, how does the judge rectify that if it's too much they award? It's called a remitterer action. It's called a remitterer. And depending on the rules of the jurisdiction, the judge can either just do that as a judicial order, or sometimes they have to order a new damages phase, depending on the jurisdiction, but it's a remitterer. They strike out the amount because it's not legally sustainable. So that's how you do it. So anyways, and then it was a little, the portion where they presented damages was also a little bit unsatisfying in just how they did it. It was very cold, and it was also a little quick. There's probably a way to do it in a way that's not so, let's break out the abacus. There's probably a way to do it that's not quite so, just break out the adding machines. I think maybe it was his tone or something. I don't know. It just was a little off-putting the way it was presented. But overall, not bad. In the playoffs the playoffs first half, 7 out of 10 needs work. Maybe 6.5 needs work. It's perfectly serviceable. It's perfectly workable. It's something that, someone could be proud of. I think a lot of it, to be quite honest, is just because they were literally tired. He said he didn't sleep the night before. I believe him. I think he was just exhausted. And so he wasn't able to do it in the way that you would anticipate because he was just completely exhausted. So, all he had to fall back on was his many, many years of training, which are very good. But the holes were a little bit apparent. So 6.5, 7 out of 10, perfectly serviceable. Just some notes. Okay, then we got to Johns Hopkins. Johns Hopkins spent the first 40 minutes of their 2 hours just talking technical stuff with absolutely no storming, absolutely no framing, and absolutely no story. It was really bizarre. I spent the first 40 minutes of Johns Hopkins close, and I didn't know what they were talking about. I had no clue. I knew what the words were. I just didn't know why they were saying them. It's like it was just a whole bunch of facts. First of all, they did start, by literally asking the jury about their favorite pie. They literally asked the jury what your favorite pie is. So that happened. Let me see if I can find it on stream because it was a moment. I'd forgotten that they mentioned pie. I blew it. I somehow managed to blot it from my mind because it was so weird. All right, so let's just watch a little bit of Johns Hopkins just as they are starting their thing, and they literally start with pie. So let's watch Johns Hopkins for some reason talk about pie.
I also want to confirm that no one approved
the justice system. For conducting this trial in a civil manner, this is a civil justice system, and I think it's a testament to that. I wanted to thank Deputy DeMizio and Deputy Coley for keeping this courtroom safe and helping you through the process. I'd like to thank the Kowalskis for listening patiently and respectfully. I know that a lot of the things I've had to say have been tough for them to listen, but they've listened with grace and integrity, and I thank them for that. I'd like to thank my trial team sitting behind me, too numerous to name.
I'd also like to thank the Academy as long as we're here, by the way.
I'd like to thank you from the bottom of my heart for your service. This has been a long 9 weeks. Indeed, we started in the summer. But you've listened patiently. You've asked great questions throughout the process, and we appreciate your active engagement. But most importantly, I want to thank these people, the people of All Children's Hospital, and they've given me the privilege of standing before you to be able to tell their story. And that's what I plan to do during my time. They want you to know that All Children's did not harm this family. Not just the people here, but the people back working at the hospital, they want you to know that. We are here because we believe on behalf of the hospital practiced safe, evidence-based medicine, and we're here to defend the hospital's right to practice that medicine. And I've put up a list here of the witnesses because you've heard from a lot of people, so when we talk about witnesses, if this helps orient you to who's who, this on this side is who I represent. On the other side are people you've heard from that I do not represent and who we are not responsible for. It's almost Thanksgiving, so I put up the pie. And I don't know if this is an interesting memory, but way back when we did jury selection, you may remember we had a little bit of fun. We talked about pie and what your favorite pie was, and I've learned that some people don't like pumpkin pie, which is incredible to me, but that will be an interesting topic at Thanksgiving. But the reason why...
He literally put up a slide with pictures of pie on it. This is how he starts. He literally puts up a slide with pictures of pie. Okay. Now, some of you guys are mentioning that they asked about what your favorite pie was in the jury questionnaire. I'm just telling you. I'm just telling you right now. If they asked that question way back when for the express purpose of being able to start their close with the pie question, right? If the reason they asked the pie question was not just, for fun or, to make things a little bit lighter, but they asked the pie question specifically so that, 10 weeks later, in closing, they could be like, remember when we talked about pie? Isn't pie fun? I mean, I can think of better legal strategies, to be honest. So, yeah. So after talking about pie, for some reason that, defies my understanding and imagination, he then spends 40 minutes talking about all these facts about other doctors and all the things they did that are not Johns Hopkins, like Dr. Kilpatrick, for example, and the Mexican doctor and whatever. And he's just like listing all these things that they did and treatments that they did and stuff. But the problem is, I don't know why he's mentioning it. Now, 40 minutes later, he tries to like sort of back end it by saying, okay, well, let's talk about Johns Hopkins and, these treatments weren't safe and so our doctors are good. But what would have been really great would have been starting with like 5 minutes worth of like preview, right? It would have been really helpful to be like, some version of Johns Hopkins is a good hospital. And they do good treatments. And the treatments that these other doctors that Maya had were doing were bad. And they were unknown to Johns Hopkins because they're absolutely batshit crazy treatments. And I'd like to tell you about these batshit crazy treatments because we actually believe in a standard of care, which is what we gave Maya, unlike the quacks that were treating her in Mexico. So they should have said some version of that, to set the scene and then talk about the other doctors and, throwing them under the bus for their quackery ways before then going to Johns Hopkins and how, they're a bright shining light on the hill. But they didn't do that. There was nothing tying it together, right? It was just a series of facts that had no particular connection to anything, no particular relevance to anything. They certainly aren't Johns Hopkins. Why are we talking about the doctor in Mexico? Is Johns Hopkins All Children's Hospital located in Mexico? Did it move? Why are we talking about Mexico, right? So they're expecting me, and also the jury, I suppose, to connect the dots for them, which is never a great idea. It's not really great storytelling. Let you figure out the relevance of all these things. So I was like, okay. So I basically fell asleep and was unconscious for portions of plaintiffs, or defendants' closing. So if their goal was to numb me into some sort of state of suggestibility, I guess that if that was the plan, maybe they were trying to purposely hypnotize me with like really stupid shit, and it was all hypnotic act, and then I'd be really pliable, and they could feed me suggestions that I would just believe implicitly without any doubt. I love Johns Hopkins. Johns Hopkins is the greatest hospital. Johns Hopkins, who's no wrong. Johns Hopkins is awesome in all their ways. Who would ever dare question them? I love Johns Hopkins. Was that the goal? Was it a hypnotic suggestion? Was that what we were doing? Was it brainwashing? I don't know. Whatever it wasn't really working for me very well, to be honest. It was just mostly boring me and making me irritated and sad. So, yeah. But then actually they did get into evidence that was helpful for them. I'm not going to lie. They did say some things that were actually helpful for them, which they probably should have just said earlier. Like, okay, the issue is, for example, false imprisonment, otherwise known as kidnapping. We had consent. Here is the form. Here is Maya's mother saying they consented. Here is an email from Maya's mother to Jack saying, no, we don't want to pull her out against medical advice. What are you talking about? We don't want to pull her out. She's exactly where she needs to be. So they're like, okay, they don't have any problem. There's no false imprisonment. Okay. As to battery, they're like, no, she wasn't held down. She wasn't, here's a picture of the room that she was held in with the video cameras. It's kind of like any other room at the hospital. It does look kind of like any other room at a hospital to me. It just has a camera in it, so it's observable. It isn't some sort of dungeon room. It's just a room for, and also the fact that they were observing her on video isn't odd. Here are medical records from another hospital showing that they did a similar video observation study like we did. It's part of the normal practice. And we weren't battering her. We were trying to comfort her, and we're just trying to show her a little love and care, and we weren't doing anything wrong. I was like, okay, that can work. I'm not sure if the jury's buying it, but at least it's a viable argument. So at least they started saying things that are legally viable. That was nice. They get into the medical malpractice and basically are like, yeah, all these other doctors are quacks. We're not quacks. We were providing good quality medical care, and Maya got good quality care, and her condition is a little bit difficult because it's a diagnosis by exclusion, and we were simply doing the best we could, and our standard of care was excellent. We didn't do anything wrong. Okay. And then they also provided numbers for damages, which honestly are much more realistic. To be honest, it's okay, we don't agree that you should fine for her, but if you do find her for her, then we think $500,000 of damages for this, or $1 million of damages for this, or $2 million of damages for this would be more in line with actual harm. Which, to be honest, they're probably much closer to reality than Maya's parents are. Maya's parents are really asking for the moon. I know Maya's experience, for example, for the photographs and all was horrific, but how much is that really worth in sort of compensation? How much is that really worth in sort of making her whole? How much is this treatment worth when we had permission? How much is it worth? I thought it was, they were making much more reasonable arguments. So, again, I think the jury is likely to blow them out of the water. So my view is kind of immaterial because I'm not a member of the jury, and probably some of you guys are very thankful right about now I'm not a member of the jury. But, I can only provide my perspective for whatever value it has and go from there. So, yeah. Go big or go home, ask higher. Why ask for a small amount when you could be getting more? Well, you don't want to irritate the jury the other way. You don't want to, shoot the moon too much and ask for something that's unsustainable, because credibility is a lot to the jury too. So you don't want to completely shoot the moon. So, yeah. So that's where we're sitting. That's why no one wants a lawyer sitting as a juror on civil law. Ouch. I'm a member of society too. I'm a good uncivil. I'm a good uncivil. I can be on a jury. I'm a member of society too. I'm a good uncivil. I'm a good uncivil. All right. So let's listen to Maya's parents. Let's listen to Maya's parents' rebuttal portion of their testimony, and we'll go from there.
You have the floor.
Please the court. What you heard was exactly why we need punitive damages in this case. They still don't get it. Well, I think I heard that they agree with some of our liability positions. They still do not understand institutionally, as voiced through their attorneys, how awful this was. How terrible it was, the things that they did here. This is Johns Hopkins. This is Johns Hopkins All Children's Hospital. This is who they really are. This is a place.
Now, I have to say, from a pure rhetorical standpoint, this is pretty good. This is pretty fire, right? This is a pretty fire rebuttal. And like, this is who they really are. You know, they still don't get it. So I appreciate the rhetoric here at the Open. They really did a very good job of getting my attention, much more so than they did incidentally in their first attempt. But their rebuttal, it starts off with a much more fiery bang, and I'm here for it. I did appreciate it.
Where they call,
and then they put up all these like exhibits. Learned today that Kennedy girl mom self-harmed. Sorry, my prediction was secret. A picture of Maya on the stretcher, you know, having her clothes taken off and photographed. We may need to try what's going on with mom. I wouldn't put anything past her. Fortunately, at 10 years old, she can't perform the charade effectively 24/7. This is like a little nice little slide of horrors. I appreciate the mosaic effect of the whole thing. It's very nice.
little girls who just lost their mom, ketamine girl, and appear to have absolutely no problem with the fact that they knew this was coming and said nothing and did nothing. This is who Johns Hopkins is. They say, I wouldn't put anything past her mother. Put what past her mother? Trying to take care of her child? She can't perform this charade effectively 24/7. They're talking about a 10-year-old. Maya feels ACH is lying. Wonder why that is. What kind of doctor-patient relationship is that? What kind of pediatric relationship is that? Why would you want to keep a child there when the child doesn't want to be there and just wants to be away from you in this first week? Maya feels ACH is lying to her about her mother, that the doctors are lying about her parents. This should never even begin to start up in a pediatrician-child relationship. It should never, ever be. This is who Johns Hopkins All Children's Hospital is. It's a place that retaliates against its own employees for bringing things out that are negative, and retaliates against any parent who decides they want to do something different. All I heard the other side was, it's our standard of care. It's our standard of care. It's our standard of care. Who cares if it's your standard of care? A parent has a right to decide their child's own treatment. They don't get to choose it. And that's a lot about what this case is about.
Fire. Very good. Good rhetoric.
It's about an organization that is so screwed up that it actually thinks it's a good idea to force parents to accept their way of doing things. And if the parents don't, then they've got to find different ways to punish them. That's where all this stuff came out. It didn't work. Made the greatest mistake you could ever make to these people. She said no. They still don't freaking get it. They still don't freaking get it. Here are the punitive damages questions. 5, 10, 15, 20. Those are 4 opportunities, if you agree with the plaintiffs, that this is completely and utterly intolerable. Punitive damages are for willful, wanton, and malicious character, behavior. There's absolutely no question that risk management, with the concurrence and knowledge of the general counsel, which is as high as you can get in this, planned and instituted this entire idea of stripping this child down, taking photographs of her, not letting the parents know, against the child's will. They knew. They instituted this from the very top of this organization. What does that tell you about what's going on here? What kind of ultimate lack of humanity? There needs to be some captain of this ship, and there never was. It was totally dysfunctional, the way this hospital operated. No one was checking. No one was making sure to see how this child was being taken care of. No one was looking to see how their own employees were behaving. And it wasn't just one. Yes, it has to be clear and convincing, but when you have internal memoranda from the highest up in the hospital down to a Kathy Beattie telling her to do something like that, that's clear and convincing. That's from the highest part of the hospital down to do something despicable. You don't do that. I heard a lot about attacking Beata. I never figured out why. If they really... Okay, again, pardon me if I'm confused on this. If these doctors, who are all licensed and specialists in CRPS and pain control, prescribed what they think was too much medication, why go after mom? Why not go after the doctors?
Good question.
Where have you seen anywhere where anything that Johns Hopkins did questioned the actual doctors writing the prescriptions?
Good question, right?
No, that's too hard. That's too hard. That might cause problems. Now, it's easier to go after Beata. Plus, she insulted them by not agreeing with what their routine was. Think about this, though. If the whole point here is that Beata, who is just trying to take care of her child, by the way, is taking her child to places and trying to get treatment, and these doctors are prescribing all of these excess medications, or this won't work or that won't work, why are you attacking the mother? What possible good does that do? After the Mexico trip, one of their pulmonologists, who actually was a very nice man, Dr. Kreisman.
Amy in chat asked, do I have any children? I do not have any children. I am still looking for Mrs. Uncivil, so if you're interested, holla. But let's go back to the story. Well,
saw Maya, having seen her 2 times before Mexico, and now 5 months after Mexico, and says, talking about the treatment in Mexico, the long-term ketamine infusions, this is a new child. Do we have that? This is a new child. She's bright. She no longer appears to be in pain. On physical examination, she's examined in her wheelchair. She is a completely different child from the last exam, which was 2 months before Mexico. By that I mean she is not in any pain. She is not moaning. She is smiling. She is interactive. She is very engaged. Oxygen saturation is 100%. Weight 25 kilograms. This is an experienced Johns Hopkins doctor. Remember I said there's a lot of the outside doctors I thought were trying to do their job. Apparently Dr. Kreisman was. And 5 months after, here he is saying, this is a different child. That's their own physician saying that. And please keep in mind, around this time, their surgeons also put the port into her chest to facilitate the ketamine infusions. What you are seeing here is an incredible example of revisionist history, picking little bits and pieces out of the record and trying to fashion them into some blame. What did the Kowalskis do wrong here? What was it? What was the purpose of all this, other than arrogance and the belief that ultimately they could get away with it? Forcing the parents to agree with your own version when you don't even have the doctors with the right specific skill set to disagree reeks of arrogance. It reeks of people who are not getting out enough medically, who are not keeping up with the latest trends. If they're going to be Johns Hopkins All Children's Hospital, which is supposed to be the Johns Hopkins name, one would think that they would be right on top of the very latest treatments, right? They weren't. And they relied on this Sally Smith character to come in, and she's a pediatrician, and there's nothing against pediatricians. I'm not down on pediatricians. I'm down on pediatricians who think that they're neurologists or anesthesiologists with a subspecialty in CRPS and a subspecialty in ketamine treatment and treatment for what is known as chronic CRPS. See, Maya had already been through all of those things that Johns Hopkins was suggesting.
Yeah, I like that. Like, who is this person, Dr. Smith? No, I'm not down on pediatricians. I'm just down on them when they think they have the same expertise as this person who's hyper specialized in this thing. Which, yeah, I mean, it's all fine and well to have generalized knowledge. It's all fine and well to be well informed on a wide variety of things. But when you're dealing with someone who's hyper specialized in an area, it's like, and you're not hyper specialized, you might want to proceed with a note of caution, because maybe they know something you don't, because they're hyper specialized. Right? There's this special arrogance. It's like, I'm a doctor, or I'm a PhD. It's this special arrogance that you're instantly smart in everything. No, like, if you're a PhD, you're smart in one thing. Right? You're not smart in all. You're smart in this one thing. You're the best at it. Right? That's why they give you a PhD. You're literally the best. No, there's no one better than you. You're number one. But to say that you're better at everything, right? And it's like, you remember what they call the person who graduates last in their class from medical school? Doctor. So, maybe have a little bit more humbleness there.
And Beata knew it. Beata knew the only thing they had within that first few hours they were questioning them. That's why tensions were getting a little high. Are you going to be able to increase the amount of ketamine for my kid or not? No? We're out of here. Oh, wait a second now. This might be dangerous. There might be something wrong here. Now, we want to leave. Okay. Well, just let us hold on for a second. We'll see what we can do. Ask yourself this. Where were their psychiatrists? They brought in little bits and pieces of other hospitals, psychiatrists, or in one case, a nurse's assistant, pediatric physician's assistant who's a nurse, to make a diagnosis or a potential diagnosis. And they brought in another instance, a nurse in another hospital who thinks this might be conversion disorder. Ladies and gentlemen, where did you see their expert come in and confirm any diagnosis of conversion disorder or any psychosomatic condition that outweighed that it was CRPS? They're Johns Hopkins. They can't find a psychiatrist to come in and agree with them?
Nice burn. Nice burn.
Attacking Beata. Why go after Beata? I guess it was easy pickings. I guess they figured, I don't know whether it was her accent or just the way she acted or what it was, but they sure did hone down on her. I can't put anything past her mother.
Good stage presence. Good delivery.
Trying to and have tried to through this.
It's if you had to pick a criticism, fumbling with the paper is a little distracting, but he's good in pausing. He's good on the pacing of the delivery. His vocal variety is okay. Could be better, but not bad. A little bit monotone, but not like horrible. Johns Hopkins was even worse when it came to this problem, incidentally. but he's really his language is very descriptive. He puts you there. He's good on pacing. He doesn't step on his own lines. He gives his lines moments to breathe. He is speaking at a very good space. He is well equipped to the task. It's much more organized, incidentally, than his first half, at least in my opinion. So, for the rebuttal, it's a little bit better. Like 8.5. It's a little bit better. It's a little bit more organized, a little bit more passion behind it, which is also nice. So it's good. It's a solid effort.
Use videos and photographs to try to express to you how the child was doing at different stages, because I believed that you would trust your eyes. You would trust what you could see and watch. And that's still true for after she got out of there. It still took her 10 months to get back to even close to a baseline, and another 6 months of transitioning off to get off of those crutches. And she did it through hard work. And instead of it being looked at as a good thing, this is a sign somehow that they're right. They're actually taking credit for all of the incredible hard work Maya did on her own. And we all pretty much know why she was doing this. She wanted to prove something. She wanted to prove to them she could do it. It hurt like hell. She had no ketamine, no pain meds, scared out of her wits, the family. And when you read there those orders, you'll see that for the last 10 days to 12 days, the judge said, and no ketamine. Do you really think that this family was going to go back and try the ketamine that put them right back there in that power system? You think they're really going to go back to that? No. And that's why they didn't go back on the ketamine. The ketamine worked. It would have made her life so much easier, but Johns Hopkins, they ended that. In the Civil War, they would cut off soldiers' arms and legs with a shot of whiskey as the anesthetic. That didn't make it good. That didn't make it state of the art. That's just all they had back then. The ketamine was there to help her get better and to help her reach the best that she could be. And they took that tool away from her.
Your Honor objects. This is immunity issues.
Sustained.
Think of it this way. They believed, I gather, that Maya had recovered because of their treatment. What she did was have a remission. And we've spent the past 8 weeks explaining CRPS to you. It's a devilish disease. And you can go for months, weeks, months, years, you can have a change like that. Exactly what happened in November of 2020, and then again in 2022. And think about this. This is during the period of her life where her immune system is at its absolute best. What's going to happen when life starts to take a few chunks out of her? It's not a very good thought, but she's brave, so I think she'll get through it. But it's going to be a lot harder on her, and it shouldn't be, because let me get to a point, this causation thing that the defense is talking about.
You've consumed an hour and a half total.
Say it again, Your Honor.
An hour and a half total you've consumed. 30 minutes left.
Thank you, Judge. In your jury instructions, you will see an instruction on causation. And what it's going to say is that it doesn't have to be the only cause for you to award damage. It has to be one of the causes, and in the terms of suicide, a substantial cause. So you can have two forces acting and still...
By the way, this may just be me. It may just be me, but every time that door opens and closes, it sounds like an old school iron lung. I can't be the only one that hears it. It can't be just me. All right, so listen to this door.
It has to be one of the causes, and in the terms of suicide, a substantial cause. So you can have two forces acting and still award damages for it. And if it is the aggravation of a pre-existing condition, which in this instance would be the CRPS, you can look at the way she was before, and then you can look at after the tortfeasor, in this case Johns Hopkins, aggravated it, to see how she was after. Now here's the key. You can divide that up if you have the evidence to do so. Typically the evidence is where a doctor comes in, qualified physician, and says, okay, 50% of this, 60% of this is pre-existing CRPS, and 40% of this is the aggravation part. You don't have that evidence here. You don't have that testimony in the record. Under the instructions you have, then, whatever CRPS she had before it was complicated with PTSD, depression, and a failure for the first round of treatment to succeed, whatever that ended up to be, unless you can find a way to divide it up without medical testimony, 100% of what she ends up with is on them.
I object as a misstatement of the jury.
It's not. So, when you're considering back there, well, she did have CRPS beforehand, and that's a difficult disease, and I don't know if we can really blame Johns Hopkins. Well, you can't blame him for her having CRPS walking in, but you darn sure can for what happened walking out. And the fact is that with the post-traumatic stress disorder, absolutely, I don't want to say earned, but imposed on her, and the depression from a variety of factors, not the least of which is losing her mother, that aggravated it and will continue to aggravate it down the road. And here's the problem. What you've seen in the November of 2020 relapse was because of a psychological factor. That's what triggered it. That was not a physical factor. When she had the relapse, right before she went in during October of 2016, that was a psychological factor. So you have what's known as a clinical history of psychological factors aggravating her CRPS, right? You had the CRPS, and now you've got an overlay of a CRPS that has been complicated because the first round...
By the way, I didn't say thank you earlier to all the people who are new subscribers to the channel. I really appreciate it. 124,367 right now. That's really nice. I just want to say I really appreciate everyone who's subscribed and hit the subscribe button. I really do work hard to bring you good quality content and good quality legal analysis. For those of you not familiar with the channel, we do a lot of Supreme Court review in particular. And recently, for the first time ever, I've been experimenting with scripted content. I'm not sure how well that's going, but people seem to like it. So, if you haven't already, if you could give it a subscribe, I'd appreciate it. If we could hit 125,000, hey, we're an eighth of the way to the million, So, hey, we're making progress.
Of treatment was not completed. The glial cells that Dr. Chopra talked about, that was not completed. That made her more susceptible to longer, more intense, more frequent of these relapses.
Oh, yes, and one of my mods kindly reminds me every Thursday evening we do have a regular scheduled stream where we do a legal news roundup at 8 p.m. Eastern Time. And so we've been doing that recently as well. So if you want to hear a little bit more fun, frivolity, Thursday nights we have a nice little session. So tune in for that. Thursday nights at 8 p.m. Should be fun.
And then you had an overlay on it of psychological issues, not her own, caused by them, that are going to aggravate her situation the rest of her life. And like I said, she's at the top of her game now biochemically, Wait till you get out in the real world and you start to age a little bit, and you start to have some things, life take bites out of you here and there. You're going to have some psychological issues come up. And she's not going to be as equipped to deal with them as she could have been. Because Beata had a good plan. Beata had figured out, very smart lady, how to deal with this. And although Maya would much prefer never to have this loathsome condition, her mom had figured out how to allow her to be the best she could be. Now that was taken from her. And so when you are back there considering the damages, I want you to consider, from Maya's perspective, how great she can be, could be, with the talent she has, her intelligence, her abilities. But to get there, what kind of stresses is she going to have to put herself through in order to get there? And then, from there, how is her aggravated illness going to react? This child hasn't even taken her SATs. She's in halfway through her senior year in high school. She hasn't applied to any universities. Yeah, back in 2019, she's ready to rock. She's ready to go. Life has a funny way of affecting you, doesn't it? And after you start thinking about what you went through and you start having a relapse, you lose a little bit of initiative, a little bit of drive. If she does overcome that, though, if she does try, think about the psychological challenges of going to the type of school that she should, by all rights, go to, a top university. Think about the challenges she faces in the type of jobs that she should be able to do. That's where those big numbers come from. And they're not made up at all in any way. And I'll tell you how I know. If they had their own Dr. Bifulco, life care planner, where was it? No psychiatrist? No life care planner? If they had their own Dr. Tremp talking about the freightway to college, which is what he was talking about before all this happened to her, if they had their own Dr. Tremp, where is he? If they had their own economist to figure this out, where is she? Or him?
Where's the psychologist is a great question.
If there was somebody who truly was going to disagree with those numbers, don't you think they'd be in here testifying about it? Instead of having their lawyer come in and attempt to pick here and there at the sidelines of what really happened to this family. And it's not just Kathy Beatty or Sally Smith or some of those nurses, and there were some good nurses there. I'll talk about that in a moment, but this was a problem endemic to the entire operation, and that's why they were in imminent jeopardy, IG, of losing their accreditation to be able to continue to receive federal funding and get approval from the agency that was overarching all hospitals.
Yeah,
the
really,
industry leader there.
Really good, nice reminder there of the IG, right? Really good. Good survey was completed at Johns Hopkins all children, January 7th through 11th on 19th. It was determined that immediate jeopardy was identified at the governing body based on the survey. And they identified governing body issues with hospital leadership systems and practices in driving issues to the board. Massive education campaign and speaking up and speaking out without fear of retaliation highlighted specifically. Fear of retribution when speaking up. From this IJ. The fear of speaking up, the fear of retribution was so bad, it resulted in an imminent jeopardy finding against the hospital, which is one of the most severe things you can have as a hospital. This is a life-critical problem. This is putting patients in immediate jeopardy of life. You are going to lose your funding. This is a big deal. It's one of the most severe things. They said that there's nothing more severe than this that doesn't result in an immediate takeover of the hospital. So, and what is the problem specifically? The culture is the problem, specifically highlighted in the IJ. And he's bringing this into his rebuttal and mentioning it now. It's a very effective use of timing, very effective against the hospital, very damning against the hospital. They have this culture where you can't speak up and you can't raise issues. It's like that's when no one can say anything. That's when problems happen. Yeah, and some people are noting that people are wearing purple, possibly because Maya herself indicated that purple is a somewhat triggering color for her because it reminds her of a social worker. So I can't speak to the motivations for people wearing purple. I can't speak to the motivations, but if they wore purple deliberately to try to target Maya, I hope the jury notices. I mean, they've been listening to the testimony, right? They know that. So maybe they put two and two together. It's a pretty dick move. Or if the jury notices, because they can't help noticing you're wearing a purple tie, Maya doesn't like that, and everyone else is wearing purple. It seems like you're trying to prod her and troll her. Keep adding zeros, baby. Keep adding zeros.
This was an organization that was teetering and was trying to get its act together because its culture of people reporting problems was so toxic that they had to have multiple meetings and consultants and ideas of just how to fix it. And all that came well after the poor Kowalski family was involved. This went straight to the top. This ship never had a captain. And that's how you end up with these situations. It was a totally dysfunctional organization, and the Kowalskis paid the price. We didn't take. Nick did a great job, didn't he, on the numbers? I'm not so hot on the numbers, as we know, but they tried to minimize some of the effects of this. They tried to talk things down like, well, it was only 15 minutes that she was pinned down, stripped, photographed against her will. This is a 10-year-old girl. She's ill. She has a disease that will not allow her to escape in any way. She's in a wheelchair. She's in a place that she despises, around people she doesn't trust. And she's being photographed naked. And the way you know that is the other nurse came in and testified. Do we recall? Alcia H.C. I've got her name here. The other nurse that's seen in the picture. And she said, yes, Maya was stripped. Maya was naked. Yes, we did hold her down. And Beatty...
Sterilization evidence. Overruled.
And we also know, because you saw the deposition testimony of Kathy Beatty, in which she said, unfortunately we did. That's not something you say if you're particularly proud of what went on. Which begs the issue, then, if Ms. Beatty is willing, if you believed the other nurse, who frankly did not seem capable to me of misrepresenting anything, if you believed the other nurse that in fact Maya was stripped down, and if you believe that she was confirming what Maya testified to, and they never caught Maya in a single inconsistency in her depositions, did they? Not once. If you believe those two, that means that Kathy Beatty was willing to get in here in front of you and completely and utterly misrepresent a key fact in the case. How reliable is that testimony as to anything she has to say? Or was this the type of person getting caught who's willing to say almost anything to get themselves out of it, or what they perceive out of it? And for Jack, again, I apologize to him for him ever having to hear Detective Graham's voice again. Lord knows that's traumatizing enough for him.
Nice.
Detective Graham's techniques in attempting to flip Jack by telling him, among other things, that I'll put you away for 20 years if I think you're harming that child, and trying to get him to say things against his own wife were completely and utterly despicable. Jack was faced with a circumstance where, if he didn't cooperate with this lady, he truly feared, A, he could go to jail, B, that they were going to work some way to make sure Maya never got out of there. And even then, he did his best to protect his wife. But you know what? It did have an effect. It did have an effect because it drove a wedge between Beata and Jack. It caused Jack to question the actions of his wife. And by the end, when you read those suicide notes, you'll see, for instance, that Beata actually gave the rights to her parental rights to her sister. By the end, and this gets into what happened with Beata, even her marriage to her appeared to be brittle and with problems. Child is away from her. She believes her child to be in desperate trouble. She believes that her child could end up as another CRPS fatality. She believes that her husband, while loving her, there's a rift. She feels isolated. She feels alone. And she is motivated internally by about the strongest urge, the maternal instinct, that we know, even in all mammals, let alone human beings. When you're looking to see whether you should check yes, that it was what Johns Hopkins did, whether they were a substantial factor or that she acted on an impulse, please consider how powerful the maternal instinct is.
You have 15 minutes.
But I don't think these folks here get it. I still don't think they get it. Okay. Let's play then 2695. This was a mom who loved her daughter. What I found interesting also while we're looking at it is that the defense took...
Hold on a second. Is your video monitors not working? Okay, Mr. Reyes, I'm going to turn it off and turn it back on, see if that cycles it.
It's nice to know that even the court has technical problems sometimes. Makes me feel better when I have streaming issues.
Is it there now?
See it now?
Doesn't always go right, does it?
Did it come on now?
Well,
Is it there now? Mr. Reyes, I'm going to turn it over to the left table. We'll try that. And Mr. Anderson, I'll give you a couple extra minutes.
thank you, Your Honor.
Tech issues to fall us off. I love how we have the random Alienware laptop in the background for some reason. Who uses an Alienware?
Just to note while we're waiting here, check out Exhibit 3115, which was that recording with Beatty jumping in, and then compare it to their recording about can't talk about the case. It was Kathy Beatty. No, if we can play.
You think he's back there playing League of Legends in court? That'd be good. Maybe he's pulling a Sam Bankman-Fried, playing a little League of Legends in between doing lawyer duties, you think?
What I'm trying to show here is two things. First, the relationship here between mother and daughter, and a little bit about what each of them lost.
I love you.
Can you see it?
You can see that.
All right.
Now go down
Got a
slowly.
big one.
Go down slowly. Good job. Good job. Very good. Excellent.
Is she supposed to still be faking there? I'm losing my timeline on whether or not they think Maya had CRPS or not.
All right, not for nothing. Screw you, camera guy. Screw you. I am pissed off by this. I really am. This for me is the reason I think judges don't want cameras in the courtroom. At least some of the reason why is because of this bullshit. Let's focus in on Maya during a moment when she might be vulnerable, and hope we get those precious tears on camera. I'd be so pissed as a judge. It's like, if this is the shit you're doing in my courtroom, it's like, no, you can't. If you want to have cameras in the courtroom to like look at the witness, look at the evidence, look at the lawyer, look at the judge, that's fine. But this gratuitous bullshit, screw you, camera. Well, actually, it's not strictly speaking to the camera guy. Screw you, producer person, whoever you are out there. I don't know who you are, producer person working at Long Crime or wherever bullshit you are. You're a horrible monster. You're trying to get your clicks, so you get your tears for this, so you can show Maya crying on whatever evening news bullshit program you have. You're a bunch of bastards. Also, on a more direct level, you're threatening the entire idea of cameras in the courtroom because of your bullshit. Thank you.
Playing piano for her mom. I don't think I'm going to try to go through every single tidbit that they pulled out. I go back to, again, when I woke up at 1:30, which is, I've been in the same courtroom with all y'all. So we all heard the evidence, and you all wrote a novel for about every witness. So I have great confidence that you will put everything they said into the perspective of things. One thing that really upset me was this idea that when she was in room 709, she could either escape or it wasn't that big of a deal. Somehow I believe that having to defecate on yourself is a pretty big deal. And if she couldn't get a nurse in to even help her over to the commode, it is really difficult to believe how Maya would be able to escape that room.
Hey, camera guy.
We're dealing with here.
Hey, camera guy. That's not where the voices are coming from. Hey, camera guy, you're looking at the wrong thing. There you go.
Just pick at the edges of what was going on. I don't think they've rebutted anything that we've said. They've come in and tried to show you inconsistencies. But here's the thing about human beings and trying to recreate history this long ago back. This family's been seeking justice for 5 years now, 7 years since this happened. Pretty brave family. And you're never going to have everybody agree on everything. Moreover, if you did, such as what I think happened with a lot of the defense's witness, they sounded remarkably the same in a lot of things they were saying. I don't think that's a good thing. I think that as jurors, you're able to tell when another human being is being candid with you, frank with you, and really trying to tell you what's going on, or when they're telling you something they are trying to get you to believe and talk you into something. I brought in as many live witnesses as I could because I believed each one of you would prefer to have the human being here in front of you so that you could judge for yourself all of their different reactions to things, so that you would be able to know when somebody was just not comfortable or not. And the nurses at the end, yeah, some of them were nice, but some of them just seemed like they were trying a little too hard. The shotguns thing drove me freaking nuts. And so I just don't think it was effective to have people come in with sort of a canned speech about this. Because I kept saying to myself, if you cared so much for this child, where were you? She had to be trying to express some things. What Maya said, and it's pretty smart for a 10, 11-year-old, she thought, look, maybe if I'm super nice, they'll let me out of here. That's why she was going through all these things. We're talking about a child who's trying to survive in a very bad place. She's trying.
I'm sorry, did the video monitors come back on?
Now they're on.
I apologize.
It's okay, Judge. And in the end there, I thought with putting up the photographs of Maya just trying to go out for an hour at her homecoming, I don't know what they're trying to say there. Is that evidence she's somehow fine? Maya waits till the end of the day before picking a dress, not knowing if she could even go because of where her pain was in. And she didn't have her mom for this important rite of passage. No mom, daughter prom shopping, no pre-prom makeup, no nail sessions with mom, no mom for the excitement of pre-prom photographs. And after it's all over, she comes in here and sees that they've found on somebody else's, a friend's, social media, a picture of her. I don't understand the relevance of that. Did they not hear through all of this that this disease is such that you can have a wonderful day and then have 4 bad days and then 2 weeks or maybe a month of a great relief?
Hey, camera guy.
2 or 3.
That's not where the
And then
voices
end
are
up
coming
with
from.
4 days in your room in a fetal position. Did nobody pick up on that over there? I'm hoping that you will see. Yes. I know you're ready to get back there and do your job. I know you are. I try to wrap up. It's a tough time for a jury because they're like, get back there. Okay, you told me all this stuff. I'm ready. But please, when you go back there, think about how life really works. Think about what it took for them to get here. Think about how important these ideas that they were fighting for are. When you're considering damages, think about this. She looks a heck of a lot like her mom. And I think every time she looks in the mirror of the rest of her life, she's going to get reminded of all of this. That's a long time to continue to live through something like this again and again. Thank you.
Members of the jury, we're not quite finished with jury instructions. So what I'm going to ask.
So I think that's everything I wanted to show you from today. So yeah, that's basically the summary. The conclusion was better, and I still think the jury is going to award pretty sizable damages for Maya, and then we're off to appeal on these issues, and God only knows what happens next. You know, and I don't know what I would do in this case. Not for least the reasons I haven't been listening to it for 9 weeks. So I don't have a complete enough factual picture. And even if I did, we read through what did we count at? 48 questions that we broke it down to. 48 questions we broke it down. The jury has to really consider and ponder. If they take the rest of the week, it wouldn't surprise me. So, it's a lot to go through. So. The judge has not said anything about the sanctions. There won't be any sanctions. Nothing meaningful. There's no sanctions at this point. Nothing that's going to be legally operative. Let me read some super chats that came in today. Lynn Berry became a member. Thank you for hitting the join button. Big Bird became an uncivilian. Thank you for hitting the join button. Guy Seppi gifted a membership. Thank you. Magical Mary gifted $4.99. Said, "Hey Kurt, if the jury splits on charges, could there be 2 appeals?" Yeah, easily. Kiska Hamlin has been a member for 12 months. Thank you for hitting the join button. Duncan Idaho gifted $5. Say, "Come on, Kurt. This is literally the only time jury gets to flex its muscles and stretch a little." K-Rab gifted $4.99 to say they spent several hours looking for docs. They are frustrated. Tomorrow they'll hear the testimony. It'll be fine. They've already decided for Maya. I think you're quite probably correct. Becca Lynn became an uncivilian. Thank you for hitting the join button. Marcia Barneck gave me a super sticker of a woman with starry eyes, $19.99. Very nice. Thank you very much. Chelsea became an uncivilian. Thank you for hitting the join button. K-Rab says, Peter Trego says sometimes the lawyers agree ahead of time that if a jury needs to drop out during deliberation, they'll go for 5. Yeah, but why would they? And I wouldn't bank on it. Guy Seppi gifted a gift membership. Lisa Boo has been a member for 3 months. Guy Seppi gifted 5 gift memberships and then gifted an additional membership. Thank you very much. Desante Salzar says, do you think this case could end up going to Supreme Court? Florida Supreme Court, if Maya wins, basically 99%. I'd be amazed if it doesn't wind up in the Florida Supreme Court if Maya wins. Guy Seppi gifted a gift memberships. Laura said, why will it go to the Florida Supreme Court? Because it's novel issues of law and the court's trying to invent something without express legislative approval. They're trying to invent a new cause of action right before our eyes. So there's no chance the Florida Supreme Court doesn't speak to that issue. Mama Smith says, if verdict reached unsettlement, verdict stays? Yes. Although, strictly speaking, I don't know that for sure, how that works as a matter of law. But I'm going to go with yes. They can obviously settle at any time. Johnny Depp settled during appeal. So they can settle during appeal too. So they can settle at any time. So if they settle, they settle. Whether the verdict remains in place, I suppose it's a little bit moot at that point, but okay. Guy Seppi gifted a gift membership. Been there, done that, gifted $4.99 to say, I like your opinion on the issue. Seems like the hospital did play some negative role in the mom's mental health. I think that's possibly true, yes. Although it's a little bit challenging to separate out the medical stuff from the intentional infliction of emotional distress stuff because it has to be targeted at Maya's mom, which is a little bit challenging on the facts. But then again, I'm skeptical of the entire cause of action, so Jebs became an uncivilian. Thank you for hitting the join button. Sandy, our mod, gifted 20 gift memberships. This is very kind, Sandy. Thank you. $10 from JT, who said, I'm just 3L, but I agree with you. Applaud for always taking a tough crowd on the IIED. P.S. I've always worked for plans firms. I wish it were different. I'm new and I'm glad I found you good analysis. Thank you. Masha Barnack said, Kurt, do you know if the judge passed on the sanctions? I think the sanctions remain technically pending. There will be no sanctions. If there are, they will be de minimis. De Novo became an uncivilian. Thank you for hitting the join button. Laura gifted $1.99 to say, do you think they will change the rule on child services? Can't speak to that issue. I wouldn't bank on it. Guy Seppi gifted a membership and then gifted another membership. De Novo gifted 20 gift memberships, then gifted 20 more gift memberships, then gifted 10 more gift memberships. Thank you, De Novo, for all those fine memberships. That's a lot of memberships. Thank you. Brianna Pickney for $9.99 said, I understand that as soon as this case was open, that info was off limits, but why can't they talk about that JHCA had a concern and the call was the domino that started all the madness? You mean, because privilege issues. It deals with immunity issues because the state is a sovereign. It deals with sovereign immunity issues, and it deals with a privileged report because the hospital is a mandatory reporter. They're obligated to report as a matter of law. So they can't mention that they can't mention Johns Hopkins had a concern and called the state because they're required to call the state. It's a privileged communication. So it's off limits, that's why. Guy Seppi gifted 10 gift memberships. Tony P gifted 10 gift memberships. Manders13 gifted 20 gift memberships. Thank you all. Burr F90 said, Kurt, serious question. Why on earth are people allowed to sue for $220 million if the judge has no choice but to reduce the award to the legal max? Talk about slap in the face. It's just wrong. Well, the reason the judge doesn't tell you the legal max is because the jury might then award the legal max reflectively. And that isn't really fair either. So think about it for a second. If the judge told you, okay, you can't award more than $5 million, then the jury might say, okay, we're just going to award $5 million, right? Because they just want to punish Johns Hopkins. If they know the limit's $5 million and anything under than that is legally tenable, if they just want to punish Johns Hopkins, they'll give them $5 million. So the reason they don't tell them what the max is specifically so the jury will come up with a number they need to come up with. So if the max is $5 million, but they say $3 million, then we're fine. If they say $6 million, it's like, well, then it's not sustainable as a matter of law. But I didn't tell them that, so it didn't pollute their decision making. Right? Everything is guardrails on the jury. Right? This is all guardrails on the jury to make sure the jury reaches a correct conclusion. So if the jury reaches the right answer, then great. If they don't reach the right answer, then we'll fix it after the fact. That's what appeals and post-trial motions are for. Paul John T gifted $1.99. And what's also one of the reasons, by the way, they don't tell them in states where there's a punitive cap. So, for example, this is exactly why in Virginia, for example, they didn't tell the jury that there was a cap on punitive damages. Right? Because if you tell the jury, hey, you can award as much compensation damage as you want, but you can't award, what was the limit in Virginia? It's been a while. $250,000? I forget. Doesn't really matter. Right? If you tell them that, then they might shift what they thought were punitive damages into compensatory. Right? So it's like, oh, we can't award more than $250,000 of punitives, but I'd really wish it was $500,000. So we'll just pretend that $250,000 of it was compensation when shifted around. Right? $350? Yeah, so it doesn't really matter. But that's why you don't tell them, because they might start doing things they're not supposed to do. The jury's just supposed to make the right award, right? If you tell them there's a cap, they might make decisions other than they're supposed to make because they're gaming it. And we don't want them to game it. We want them to make the right decision. So that's why. That's why. Let's see. Paul John T gifted $1.99. Christine Pygon became an uncivilian. Thank you for hitting the join button. Kisha Lean has been a member for 5 months. Karen G gifted 14 GTQ to say, I liked your scripted videos. Thank you. Fanny Pack has been a member for 4 months. Robin Sermatine has been a member for 3 months. Brentwood Chic gifted 20 gift memberships. Redtail became an uncivilian. Thank you for hitting the join button. Charlie Raven became an uncivilian. Thank you for hitting the join button. Jordan Patterson gifted $4.99 to say, is it still a privileged call if it's done in bad faith? That would be hard. And I don't know. Maybe. But that would be really difficult. Probably. I don't know for sure. But I'm going to go with probably yes, but I don't know. And it'll be really hard to prove it was done in bad faith. That's really difficult. Peggy Cole gifted $9.99 to say thanks for covering this, and then Peggy Cole just gifted just now $4.09. So jury came back with 2 questions. We went over them. To work computer, how to get economics. Yeah, we went over the questions at the start of the stream. The jury apparently was trying to have a funny joke or something. It was really weird. So, yeah. So that's all. There shouldn't be a max. Oh, I mean, compensation is unmaxed, but compensation is meant to compensate, right? Compensation is to compensate. Compensate is how much were you harmed. So it's not maxed in principle, but it's maxed by facts. Punitives are maxed by 3x. So yeah, there's no cap on compensatory, but they actually have to be compensatory. So how much makes Maya whole is the number, and anything more than that is, not compensatory by definition. So that's the nature of the thing. It was a very strange. Is Florida a state where there's punitive damages of no cap? I believe their state Supreme Court struck down caps, but the U.S. Supreme Court, I believe, State Farm, I believe is still good law, said 3x. So 3x is the effective cap, I believe. So I'm going to say 3x. Is a Pokemon in the picture over my shoulder? No, those are not Pokemon over my shoulder. Those are Scottish kilt patches. They are kilts designs. They're not Pokemon. Compensatory damages are limited. Again, compensatory damages are limited by the facts. They're limited by how much it really takes. Tartans, thank you. Tartans was the word I was looking for. Thank you. The tartan swatches. Compensation damages are limited by the facts. They're limited by how much it takes to make you whole. So they're naturally limited. But theoretically, they can be as much as it costs to make you whole. Right? They can be billions and billions of dollars. Like, for example, like compensatory damages for Sam Bankman-Fried would be like $15 billion. If you were trying to calculate out a number, because that's how much it would take to make everyone whole. So there's no limit on compensatory except what it would actually take to compensate. What does it take? And sometimes that number is not very much, and sometimes it's a lot. So it's naturally compensated. Compensatory damages are not limited in Florida. I'm aware of no state in which compensatory damages are limited. It would amaze me if there is any state that limits compensatory damages. Lots of states limit punitives, but I can't think of any state that limits compensation. Yeah. Cap on punitives is 500K or 3 times 3x. Yeah, that's perfectly logical. I thought the overall cap by Scottis was 9x for punitives. Depends how you read the case, but 3x is the better read to me, but we don't have to argue the finer points of that right now. Is it really that wrong that the juries would want to award damages that would actually be felt by the defendant? Is it wrong? Well, the damages are for what they're for. Compensatory damages are by their nature designed to compensate. So the ability of the person to pay does not influence what compensatories are. I am not a particularly rich man, but if I burn down your $1 million house, I owe you a $1 million house. If I burn down your $10 million house, I owe you a $10 million house. If I burn down your $1 shack, I owe you $1. So compensatory damages by their nature are not in any sense tied to what the person can pay. They're tied to what the person was damaged. That's what they're for. So that's what they're for. Punitive damages are limited because the Supreme Court said that, it was unfair. So that's just in the nature of the thing. I don't know what more to say than that. It's just, the damages are what they're for and not for other things. What if the $10 million house would now cost $20 million to build? Then it's a $20 million house. What does it take to make you whole? There's lots of different ways of potentially measuring that damage, but what does it take to make you whole? So if it costs $20 million, it's a $20 million house. My prediction on the verdict is the jury is going to award big numbers. I think the jury is likely to get into or close to 9 figures. I think we're going to talk about some pretty big numbers. I wouldn't be surprised if they pretty much blow this out the top. It's really not about the claims now. Well, for better or worse, I'm a legal education channel, so I'll give you the legally correct answer. You may very well be correct that the jury will ultimately ignore all this and just award a number because they feel a certain way. But I'm going to give you the legally correct answer because I'm a legal education channel. That's what I do. Anything else is not particularly helpful. Could this jury just award a big fat number because they're pissed? Of course they can. But, what they're supposed to do, well, that's what I'm here for. I'm here to teach you the law. Anyone can abuse their power. Anyone can abuse their power. Whether it's a king or a president or a governor or a juror. And I don't think it's good when jurors abuse their power. I don't think it's good when the government abuses its power. And when the jury is serving as a jury, they're the government. When the jury is serving as a jury, they're the government. So it's the government abusing its power. And so that's not good. I'm not in favor of the government abusing its power. There are rules and laws. And they need to stay within the bounds of the rules. And if the jury goes outside the bounds, then they're behaving in a tyrannical. They're tyrants. It's a jury. It's tyrants, and that's not good. Tyranny is bad. Don't do the tyranny. Follow the law. Yeah. And at the risk of pointing out the obvious, power that can be used to benefit you can be used against you and probably will. So I think we can all point to times when the government has done things we don't like, and we want the government to be checked. And the problem with giving the government power is that it tends to be able to be used in any direction. Like giving the government power is like giving a dog a lead. The problem is the dog can kind of run in any direction. If you give the government enough power to run far enough in one direction, the problem is it kind of implicitly gives them as much power in any direction. And so keeping the government running in the direction you want and only the direction you want in only a way that's going to benefit you, it's kind of a problem. So, I don't really like it when the government abuses its power. That's bad. So, if Johns Hopkins deserves to win as a matter of law, they deserve to win. Right? This can't be. In the end, your sympathy and empathy for Maya can only go so far, in my humble opinion. If you allow your empathy and sympathy to go beyond that, you make a bad decision for what you think is a good reason, but then you're just a tyrant. You're using your tyranny for good, at least in your mind, right? You're doing it because you have the best reasons, don't you know? You're a good tyrant. You're abusing the law because you see an injustice and you want to fix the injustice. You're using your power as tyranny because you have the bestest of reasons. You don't have to think very hard to see how that can go wrong. So it's very beneficial, at least in my humble opinion, to keep your eye on the ball and look to the law. Right? What is fair? What is just? What is right? If Maya deserves to win, then she deserves to win. If Johns Hopkins deserves to win, they deserve to win. Focus on the facts. Focus on the law. Make the correct decision on the facts and the law. You'll be better off for it. The hospital abused its power. See, that's bad. The hospital shouldn't abuse its power. That's bad. Just, follow the facts. Follow the law. Make the legally correct decision. Justice for all. Justice for everyone. Equal justice under law. The rich and poor, the powerful and the meek are judged and judged alike. This is the goal. I'm here to speak to the aspiration. I'm here to speak to the aspiration. What I think of the jury's questions tonight, I didn't really fully understand it, and the judge seems also slightly confused. But I don't know what to think. I think tea leaf reading jury questions from deliberations are a bit of a fool's errand. That's what I think. I think trying to tea leaf read jury questions is a fool's errand. So, yeah. Am I okay? Other than being a little tired, I'm in great spirits. I'm visiting my parents. I'm having a great time. I'm very relaxed. I'm very chill. I'm very unstressed. So other than being a little tired, I'm doing great. Thanks for asking. I'm having fun. I'm in great spirits. Yeah, the cameraman really is pissing me off. For sure. They hid the facts and still are. That's bad. They shouldn't do that. I never told you to not rule for Maya. Just told you to follow the facts and follow the law. That's all I told you to do. And reach a just and fair verdict under the facts and the law. That's the instruction, man. Let's just see if there's anyone I could redirect to. Recurity Addict doesn't have a stream up for tomorrow yet, I don't think. I was going to redirect you that way because it seems like a nice thing to do. But I don't think a stream is posted yet. Yeah, Recovery Addict's not posted yet. Okay, no one's streaming. There's no one for me to redirect you to. Oh well. Thank you, Jules Buddha, for the gift memberships. It's very kind. Appreciate it. Thank you. HB gave 5 Australian dollars, says, thanks for your analysis. Greatly appreciate it. No good spending time with your family. Dad and I had a good day today. We had a good day today. And I'm not going to be streaming tomorrow, and thank God for that. I'm looking forward to spending some time with him tomorrow. Alright, guys, I'm going to sign off. There's nothing more for me to do. Let's see how we're doing on subscribers. I think we're doing good. See if we picked up any. Yeah, a few. Okay, we're at 124.4. So we picked up a few subscribers. That's nice. Alright, I'm going to sign off for tomorrow. We will not be doing Jury Watch tomorrow. So if there's a verdict, I probably won't, unless, it's just super duper convenient, I probably won't go live with the verdict. So you guys will probably have to get that somewhere else. And Rob from Lawn Lumber, I think, will probably be back tomorrow night. So you'll probably get your fix tomorrow from him. But I appreciate you spending some time with me. I've not been Lawn Lumber. That's somebody else. I've been Uncivil Law. Until later, I hope you have a great day. Bye for now.